We presented, regardless of their financial resources, Chinese enterprises, companies, and individuals being represented by United States law firms and United States attorneys are not receiving equal protection of the law during legal proceedings in United States courts. For the protection of Chinese enterprises, companies, and individuals facing legal challenges in United States courts, as non-parties, we perform legal analysis, and where we discover critical procedural defects, using legally binding documents, we inform both parties, the attorneys for the plaintiff and the defendant, as well as the court, of those procedural defects for the abatement of the case, meaning voiding the case from the beginning. We have identified 2 high-profile cases against Chinese enterprises, companies, or individuals, and allege deprivation of equal protection of the law in the United States District Court, Eastern District of New York. The first case, United States versus Meng Wanzhou of Huawei. In 2018, Meng Wanzhou was indicted and charged for making false statements to banks. She was later arrested in Canada and detained for more than 2 years, allegedly in violation of her constitutional protections of a speedy and public trial. The second case is United States versus China-born Linda Swen. Linda Swen is the former Deputy Chief of Staff to New York State Governor Kathy Hochul and former assistant to New York State Governor Andrew Cuomo. In 2018, Linda Swen is indicted, charged, and arrested for acting as an unregistered agent for the People's Republic of China and the China Communist Party. We have presented the evidence beyond a reasonable doubt of the successful issuing and delivering of our legally binding documents alleging the unauthorized practice of law by all of the attorneys involved in the case. We have yet to receive confirmation of correction of the court record or a sufficient response from Linda Swen's defense attorneys, objecting to our allegations of the unauthorized practice of law by all of the attorneys involved in the case. This entitles us to invoke the doctrine of legal estoppel, meaning that the allegations that we have made, the unauthorized practice of law, cannot later be challenged. We are removing the court's jurisdiction, the court's authority to hear and decide the matter, United States versus China-born Linda Swen. We are convinced that the mistrial status of the case is actually the result of our successful issuing and delivering of those legally binding documents to Linda Swen's defense attorneys and the Supreme Court Appellate Division Attorney Grievance Committee alleging the unauthorized practice of law by all of the attorneys involved in the case. We are a boutique consultancy providing private consultation and educational services for the protection of Chinese enterprises, companies, individuals, and of course Americans facing civil or criminal litigation in United States, Hong Kong, and British Commonwealth jurisdictions. We have experience successfully invoking legal estoppel in the United States District Court, Eastern District of New York, Eastern District of Missouri, the United States Court of Appeals, 8th Circuit, and the Superior Courts of New Jersey, Essex, and Bergen County. We have successfully defeated cumulatively $1.6 million in money demands of alleged attorney fees against the law firm Townsend, Tomeo, and Newmark of New Jersey from 2018 through 2021. We are among the first, if not the very first, to assert violation of the foreign state immunity law of the People's Republic of China at the Hong Kong High Court first instance on February the 21st of 2025. We hope you have enjoyed this docuseries. For now, I'm Mensa Kong, Chinese name Kong Mengxiang. Thanks for listening in. Until next time, peace.